Hello, everyone. Thank you so much for joining me tonight. As all of you know, my name is Michael Petracca, owner and operator of HJP Financial Group. You come to probably my second or third favorite topic. I do enjoy tax analysis a lot. Um, Nothing like squeezing a few more bucks out of Uncle Sam. But estate planning, I would argue, is one of those things that it's really crucial, just not every day. So, whether it's once a year or really once every year, you just sit down, figure out what you want to do, and just make sure your wishes line up with the things you have in place. So tonight, I'm going to go over some basics when it comes to estate planning, as well as some things to think about, some situations that may play out, may not to play, some angles to think about. Your goal is just to not get blindsided or your beneficiaries get blindsided, you know, where situations come up where you're no longer here, that they're now interpreting your best wishes. That's where things get complicated, especially if you have sometimes kids from a prior marriage or something like that. So again, your 101s when it comes to estate planning, make sure you take a long, hard look at yourself in terms of what you really want to accomplish, and then make sure it lines up with what you have in place. On top of that, where I think the last piece where people kind of drop the ball a little bit is they'll think about it, they'll hire the attorney, they'll spend good money putting the estate plan on paper, and then they didn't implement it. I've seen situations where people create these wonderful trusts and then never funded it. So again, you just want to start to finish, make sure everything's in place that align with your wishes. As we're going through the presentation tonight, if you have any questions, you'll see at the bottom of the Zoom screen or raise your hand. Feel free to click on that, and then, happy to answer questions as we go along. And as I'll mention in the end, everyone is more than welcome to shoot me an email. We can, have conversations about this. A lot of times just sitting down and talking to someone typically will uncover some thoughts, some angles that you didn't really think about. So again, good first step in terms of educating yourself on the fundamentals of estate planning. So with no further ado, let me share my screen. Now, as everyone here already knows, I am not a CPA. I am not an attorney. Well, why am I having this conversation? Why did a few months ago I spend thousands of dollars on a tax software? This is coming up on my 20th year in doing this. And I would say a very healthy percentage of the value I bring my clients is an understanding that a lot of professionals out there work in silos, and that there's no one that seems to be the glue or the link in between your major aspects of your finances. Your estate plan, your tax plan, your insurance planning, your investment planning. A lot of the times, these things aren't speaking to each other. That's why, and for some people, it's their CPA that kind of mushes all these things together. Sometimes it's the financial planner. But in my opinion, you need someone that is thinking about all the different angles. So again, I don't put any wills in place. I don't do any tax returns, but I constantly have to think through those lenses, because it's a lot of times, in your personal finances and all the categories, it's the one that gets neglected that pulls the rest of them down with it. But that's just kind of my disclaimer with regards to our presentation tonight. So what is estate planning? It's really every single aspect of your finances, your approaches, your goals when it comes to personal finance. So obviously, it's charitable, which is medical planning, legacy planning, gift planning, disability. It's a really all-encompassing thought process. A lot of people think, oh, it's just my will. No, there's probably a half a dozen estate planning documents you put in place. Some are optional, some are not. Some are strategies I'm doing while someone's alive. to plan for the next generation? Who needs an estate plan? So for this question, I'm talking about our basic documents, which in a few slides I'll show you. I typically believe there's four basic documents that everyone should have. Uh, I would argue once you have someone tied to you or you have a few bucks to your name. So, a situation where you're 28 years old and you just got married. I would have basic, basic estate planning documents. So I have estate planning attorneys. Some are more high end, can go into the weeds a little bit more, a little bit more trust planning, a little bit more details. When you're 28 years old, you typically need a simple, what we would call like, I love you will. Everything I have goes to you, everything you have goes to me. And you want to make sure you have your other powers of attorneys and living wills in place. But like I said, once you have a few bucks to your name, or you're married, even if you don't have a lot of assets, I would have those things in place. Well, what is factored into your estate? The long story short, there's very little exclusions to this reality. This is a situation where you're passed away. What is getting calculated? What is used to factor into the assets of your estate? Now, obviously listed here is almost everything. The two things off the top of my head that would not be included in your estate would be 529s. 529s are college savings account, which kind of break all the rules where you're the owner, but it's excluded from your estate. There's not really anything else like that that you still have access to, but it's held outside of your estate. The second one is irrevocable trusts. So these are trusts that have their own separate tax ID, do their own tax return, that would be held outside of your estate. But as you can imagine, any retirement accounts, life insurance, real estate, businesses are all going to get boiled down into your estate. Well, what is the main purpose of estate planning? So the first one here, maintain control over estate. I've been in personal finance or studying to be in personal finance since I was about 17 years old. I have a pretty good head on my shoulders when it comes to personal finance. If I got a huge sum of money when I was 22, not that I didn't have a good head on my shoulders, I just didn't have the wisdom yet. So, there's a difference between a good financial decision for your age and a good financial decision. Uh, so one of the ways that people might consider a little bit more detailed estate planning is, when you have kids in your teens or your 20s, and you say, I don't want them to get the money outright, and you want to space it out over a period of time. So we would control that kind of control from the grave. So that might speak to you. It also might speak to you, say, hey, whatever's left, divvy it up. Best of luck to you. I'm out of here. Uh, there is no right or wrong, but like I started this conversation, you need to have a conversation with yourself, see what speaks to you, and then again, make sure what speaks to you and your wishes and goals is lined up with the documents you have in place. Avoid probate. So this is the process of when someone passes away and they have assets in their estate that will be subject to the will. You have to go through the probate process, where more or less you're working with the county to bring them your will. Whoever's the executor will get the letter of testamentary, and then you're just more or less keeping them involved as you're distributing the money in your estate. I find people overreact to the how painful probate is. Yeah, I'm not saying it's the most convenient thing in the world, and I'm not saying other states don't have a horrendous experience with probate, but for the most part, New Jersey does a pretty good job of moving things along. And you might not be able to completely close out an estate as fast as you want, but you definitely can get access to capital to kind of help deal with the estate until it's all done and finalized. Reduce estate and income taxes. So this is the part of estate planning that a lot of times has nothing to do with your estate planning documents. These are conversations that we're having of, all right, do we want to maybe put a certain type of life insurance in place? Because you're not going to spend all your money, and maybe we want to maximize return for inheritance. Maybe we want to convert pre-tax IRAs to Roth IRAs because we're in a lower bracket than what our kids are going to be in. This is the moving around of your assets while you're alive with the thought process of we're not trying to create efficiency for us, but for the next generation. This could also be the concept of, maybe you're ultra conservative, but your kid's going to inherit this and he's 28 years old and aggressive. So you mentally put your money in different buckets of saying, this is my inheritance bucket, so I'm going to invest it more based on their goals, wishes, and life expectancy. And this is the money I'll need for my retirement. Again, these are different things you're doing while you're alive that has nothing to do with kind of the formal estate planning documents. Obviously, we're trying to put protections in place for your spouse, for children. Disability planning is a subcategory all by itself. If you have a beneficiary that is disabled and are receiving benefits from a government agency, it's important to do very detailed estate planning around that reality. There's certain types of trusts you can do. Do not just blindly turn over money to them. It can cause, sometimes more harm than good. This is a big one. Reduce disagreements amongst heirs. Obviously, you should get your basic estate planning documents in order. Something I personally have that I affectionately call my death doc is, a simple Word document that's designed to make my wife's life easier. So this is stuff that it's just not going to find its way into the will. All right, where are the accounts? Where's the passwords? How do you get into this? Where do I store certain things? What are my wishes for little stuff? Maybe I want XYZ of my personal effects to go to Bob. I have these things I want to have go to Sue. There are going to be a bunch of stuff that your family's going to try and figure out what would they want to do with this stuff. As much as you can lay out for them, it's definitely worthwhile. And then continuity for asset management. Not only who gets what, but who's going to be planning all of this? Who's the trustees you're going to have in place? Who's the executors you're going to have in place? Sometimes it makes sense to have conversations with these people, especially when it comes to business succession planning. You don't want to have a lot of times the first conversation people are having about this is the day after you pass away. Now, you might not want to divulge all the information. Like, hey, Bob, you're going to be 50% in my will. And then Bob pissed you off a week later and you removed him. So, yeah, there are some aspects you might want to keep private. But in things that it'll be important for it to continue in the direction that, hey, you have some ideas, thoughts, wishes, and kind of mindset around it, that's where you want to bridge the gap for those types of individuals who are in those roles. Now, what happens if you pass away without a will or intestacy? More or less, you're going to say, you know what, state of New Jersey, you're going to solve this one for me. So the state, if you die without a will, more or less has a certain pecking order on who gets what. You have no choice in the matter. It's completely fixed. Whatever your wishes get thrown out the window because you didn't put anything in place. Now, I'm using the word anything. My old man pretty much did on the back of a napkin. Something is better than nothing. Even if you handwrite it, do it, sign it in front of a notary. I don't, if you want to go on Google, there's templates. Again, something is better than nothing. The first tier I do recommend is, like I said, there are cheaper attorneys that'll help you get just the basic stuff in place. They're boilerplate, but it has a lot of the, uh, clauses that you would want to have in there. So that's what I would push you to. But if you're like, I don't even want to spend the $500, at least put some document in place. So what are the basic estate planning documents? In my opinion, there's four. So that's your will, a financial power of attorney, a medical power of attorney, and your living will. Those are the four I recommend pretty much everyone have. Now, of course, if you have young children, you need to appoint a guardian. Uh, sometimes these aren't easy questions to answer. And sadly, what I see more often than not, when they're not, people just kind of put their heads in the sands and avoid it. So that works until it really doesn't. These are one where you don't want to leave this as a to-do list item on your work pile for 6 months, for 2 years. Have the tough conversations and try and put someone there. Even if you have to switch, so be it. But, these are the things you don't want to have the government deciding for you. And then a revocable living trust, that's situational. So this is a trust, and we'll go over in a little bit, that while you're alive, completely acts like your money, but once you pass away, will avoid probate and will lay out, you have a little bit more control from the grave, and it can span time a little bit more, of how do you want your estate to be played out. So your will is your core document. Upon your passing, whatever doesn't have a beneficiary, which we'll go over in a second, just gets divvied up based on your will, and you appoint an executor who will make sure all the rules gets followed based on your wishes. We touched upon this earlier. When money goes into your estate, it has to get probated. So again, your executors going to bring your will, your death certificate over to the county. They're going to give them a letter of testamentary saying they are the executor, and then that person is responsible for financially accomplishing everything that has to be done with your will, including paying off any debts. They have to follow the rules, and just to make sure everything kind of goes smoothly. Again, in New Jersey, it's not a crazy horrible process. Other states, the classic one is Florida, where everyone has revocable trust and everyone tries to avoid probate. So what assets fall under the probate process? Like I just mentioned, pretty much anything that doesn't have a direct beneficiary. So what is excluded from your will or is not done is joint property. So if you have a property, now again, it all depends on what's titled. For the most part, joint accounts is titled joints with the rights of survivorship. So that just means whoever's the last one alive inherits the entire account. Life insurance typically has beneficiaries. Retirement accounts, again, typically has beneficiaries. Retirement accounts, just spend 2 seconds on this, a 3-4 times in my 20-year history, someone had the great idea of, it's really annoying changing all the retirement account beneficiaries, as opposed to I could just change my will as opposed to updating 8 different accounts. And so they changed the beneficiary of the retirement accounts to their estate. But they didn't realize when an IRA is left to the estate is forced to settle the IRA and close it down in 1 year. In that first year, then it gets distributed based on your will. Estates have what's the same brackets, but they get to them much quicker. Now, don't quote me on the exact dollar amounts, but the highest possible tax bracket for my married filing joint might be like $600,000. For an estate, it might be 12 grand. So you might lose 30, 40% of an estate account. It doesn't even have to be a large one when you leave an IRA or a 401k with the beneficiary of the estate. So always make sure you have beneficiaries. What you can also do for individual accounts, for savings account, checking account, turn them into payable on death accounts or TOD transfer on death accounts. That, again, it's going to avoid probate. A lot of times people's will doesn't do that much. If you put all your checking, your savings, your retirement accounts, your life insurance, and let's say you were a renter, almost nothing is going to go through probate. That's okay. And then property, any sort of trust. Like I was mentioning before, anything that's in the revocable trust follows the rules that you spelled out in the revocable trust, as opposed to what the will says. Now, these are also times you want to be careful. So, let's say you had a prior marriage and you have, beneficiaries of 401ks and maybe old 401ks that you haven't worked for the company in 10 years. A lot of people might still have the ex-spouse as the beneficiary. So their will says I'm leaving everything to my new spouse, Sue, and oops, I didn't update those beneficiaries. Again, you always want to check those. That's always a bad day when that gets turned up. Okay. So as I mentioned, revocable trust a few times. So this is something you can create now. I would argue that the main purposes are avoiding probate, and I want some control from the grave. So, hey, this 500,000, it's all going to go to my son, but he's 20 years old and he has a little bit of a spending problem. So I'm going to put these funds in a revocable trust. I can still use it while I'm alive. It still, tax purposes, flows through onto me. But upon my passing, it becomes irrevocable. And then my rules are he could touch 5% of the account. And at 25, he gets a chunk. And at 30, he gets a chunk. And at 35, just forcing a little bit more disciplined approach to finance. Again, these are choices. No one has to do these. Not everyone has to have a revocable trust in New Jersey. Just it depends how much control you want. So let's break down some of the terms when it comes to trust. So, all right, I want to put 500,000 into a trust. So I am the grantor of the trust. The next thing that takes place is we have to create the trust agreement. Now, this is not something you can create on your own. This is definitely done through an attorney. So I'm the grantor. A trust is created. In our situation, it's 500,000, and we're going to put the 500,000, and it becomes part of the trust property. And for revocable, again, I could use it as I please. If it's an irrevocable trust that is now outside of my estate, depending on how the trust is set up, who pays the taxes on it is a big factor. As I mentioned before, estates quickly get into high tax brackets. Trusts also fall into that. So you have situations where we call it intentionally defective grantor trust, in which case an irrevocable trust, meaning you got rid of the asset, but the tax responsibility might fall back onto you. Again, you're purposely doing this. You know, trust can be wonderful. It is amazing how complicated, unique, bending to your wishes they can be. They're not cheap. They might be necessary. But again, you want to have a conversation with someone like myself who's kind of thinking about the total big picture. And then again, sit down personally and figure out your wishes. So in my example, I'm the grantor. The trust property was the 500,000 in cash I'm putting to work. I hired an attorney to put the trust together. And depending on the type of trust, I might be the trustee or someone else can be the trustee. So a lot of times where it's an irrevocable trust, where you're purposely trying to get it out of your estate, you can't have control of it anymore. So you can't be the trustee. Or else the government might say, this is not outside your estate because you still have control over it. So a trustee would typically be a third person. A lot of time it's a kid or a brother or sister, but they are the trustee of the assets, and they're managing it while it's in the trust. And then the beneficiaries might be your kid. So the trustee, let's say, is your brother, and you're the beneficiary is the kids. Couple thoughts on this. Um, know your kids, know your brother. Is your brother how much is it gonna be a prick to deal with in regards to trustee? Because a lot of this is at the discretion of the trustee. In the same time, are they going to be a pushover? because most trusts have stipulations that it's 5% a year, and then for medical, safety, housing, well-being, I forget the four, but there's kind of four stipulations that it could be used for. So there's a very relationship-driven um, role. Now, some people hire a corporate trustee or a trustee from a bank. You could have co-trustees where you say, well, my brother's going to be the trustee, but I want him to make decisions with a third party that has nothing to do with my family just to make sure everything is up and up. That's fine. Again, you can do a whole bunch of stuff when it comes to trust planning. So, living trust versus testamentary trust. A living trust is just saying it is funded while you're alive. Testamentary trusts are trusts that are funded at death. You might have what's called a pour over will that says something in your will that says, everything in my estate, I want to pour over into my trust. And then it follows the trust rules. Again, there's just a million ways to put this together. This is definitely more of an art form. We've already gone over revocable for irrevocable. Revocable is fully yours while you're alive, fully taxed to you. At death, it becomes locked and irrevocable. Irrevocable, there's a real reason you're doing this. It might be elder care planning. It might be estate tax planning. But there's something you're trying to avoid by getting it out of your estate. We're going to touch upon those scenarios in a little bit more detail in a few slides. Financial power of attorney, there's two types. There's springing and durable powers of attorney. So a springing power of attorney means, let's say my wife is Melissa and she has a springing power of attorney over me. If I can no longer handle my finances for whatever reason, and that's medically been proven, then the springing power of attorney springs into effect. Now, that leaves some room for interpretation. Sometimes, someone's kind of with it, kind of not with it. More often than not, we tell people get a durable power of attorney. Now, I could put a durable power of attorney in place and not tell the power of attorney. I could keep it hidden until I think the time is right. I could tell them, hey, this is where it is. And this way they don't have to prove medically one way or another because I trust the other person. Now you might say this is where it is, but not give it to them for the purposes of, who knows if something happens in the future and I want to switch, I could just whoosh, rip it up. But if you give them out, then they're kind of out in the ether. But again, I do recommend everyone have a financial power of attorney. We recommend durable, but think about if you want to give it to them, you not want to give it to them. These are conversations you have. Medical power of attorney is a similar thought process that, all right, if let's say in a vegetated state, who can the hospital speak to? It's very important to have these in place. So again, if you're in a coma, who does the hospital get to speak to? And then living will says, well, what do I want to have happen? Do I want people to pull the plug? Do I want the hospital to keep going in any means necessary? There's no right or wrong, but don't put that decision on them. Lay it out in your will. Hey, pull the plug, call it a day. Let's get this done and over. No right or wrong, but again, put pen to paper. Lifetime gifting. So, as I mentioned earlier on, there's things we're doing with your money today that are planning for when you pass on. So one of the things individuals can do at any time is gift some money that they have to other individuals. So how this works is in today's world, in 2026, you can gift $19,000 to whoever you want, whenever you want. I'm sorry, once a year. But you can give 40 people in a year 19,000, and nothing gets recorded. Everything is fine. If you gift more than 19,000, it's fine. If you wanted to, let's say things have gone very well for you and you have a sister that's struggling a little bit and you want to give her $100,000. Technically, anything over the 19,000, you're supposed to file a gift tax return that says I gave that individual 81,000 over the threshold. It just needs to get recorded. No one's going to owe any taxes associated. You don't owe any taxes for giving to them. They don't. It's not income taxable to them. It just needs to be recorded, and it counts against your lifetime exclusion amount, which is close to $15 million. So it's not an issue, but you are supposed to file a gift tax return. Now, something to keep in mind. When you gift something, you're also gifting its cost basis. So one of the big benefits when it comes to estate planning is a step up in basis. So let's say you bought your house for 100 grand, 40 years ago, it's now worth $1 million. If you gift it while you're alive, okay, fair enough. They're not going to owe any taxes on the gift, but when they go to sell it, they will pay taxes from 100 grand, which is your cost basis. They have moved over to them. So they have a $900,000 gain. If they inherited it, they get a step up of basis. Now they inherit it. And then when they go to sell it, the cost basis is $1 million. So a lot of times people get a little nervous and I want to get, Medicaid's going to come, the government's going to come, start gifting out the wazoo. Sometimes that makes sense. Sometimes it doesn't. And sometimes it has ripple effects that you didn't even kind of think about. So again, we just want to be conscientious whenever we're gifting. It might be the right idea, but we just want to think about all the angles. So when it comes to 529s, they actually have a special little rule. If we're trying to, let's say lower our estate, you can gift up to 5 years of the 19,000 in one shot. So if you're really trying to front run Billy's college and you want to get it done and over with, they have that special little rule that only applies to them. Now, you don't also, no gift tax if you pay someone's tuition, paying their medical bills where you're cutting it directly to the institution. That's also okay in terms of gifting. Life insurance, this is just the concept of, it's a fantastic source of liquidity. Sometimes you get people with all their money's in real estate, in a business, in retirement accounts that if you touch them, you got to pay income tax. So, what we tend to recommend people have, I'm a big believer in you use life insurance to cover a risk. So if you're 30 years old, you got 3 young kids, big mortgage, and most of your working years ahead of you, you get cheap term insurance and you cover your high risk years. Now, as you're 60, 65, 70, your working years are behind you, your kids are out of the house, your debt is gone. Now you might just need a burial policy, something quick, nothing crazy, maybe 50 grand, 100 grand. Those are not bad things to have in place. Now, just know it's not a big deal today because of just the current estate rules and inheritance rules, which we'll go over in a little bit. But a lot of times when, for example, New Jersey used to have an estate tax where anything over 675,000 was hit with an estate tax. So there are ways of getting life insurance out of your estate, which are relatively cheap compared to other assets to get out of your estate. It all depends on who was the owner at death. Again, not too big of a deal today because New Jersey no longer has an estate tax, and federally it's $15 million. But I'll tell you a little secret. We're $39 trillion in debt, and we just passed 100% of GDP, our debt to GDP ratio. What that means is we're broke. And, people on this call might not feel rich, but, I could easily see a situation where maybe the estate tax goes back down to $1 million. Maybe it's 2 million. Maybe it's 3 million. So just know life insurance, you can get it out of your state fairly easily, and this avoids the life insurance proceeds being factored into your estate. Again, in today's world, not a big deal. If the estate law changes, that strategy might come back into play much more. New Jersey, we just touched upon a little bit. So going back, this was probably 7, 8 years ago now. New Jersey used to have an estate tax. They removed it. It still has an inheritance tax. So let me give you an example. You have $1 million, and so no estate tax, so your million is fine there. It all comes down to who is inheriting the money. There's what's called type A beneficiaries. So if you're leaving it to your kids, grandkids, think up and down, zero. No inheritance tax. So no estate tax, no inheritance tax. So I think a lot of people might hear, fear mongering. Oh, avoid the taxes, avoid the tax. There are no taxes. Again, if you have IRA, yeah, you're going to pay income tax because it's an IRA. But your house, money in the bank, your brokerage accounts, these things that are going to get a step up in basis, no estate tax, no inheritance tax. If we're talking up and down, kids, grandkids type of situation. When you're leaving money to brothers, sisters, cousins, uncles, friends, this is where they're going to pay somewhere between 10 and 20%. You know, sometimes you say, all right, I want to leave it to a friend of mine. He always did right by me and he helped me that one time. If you gift it to him while you're alive, you avoid that person maybe paying 17%. So this is a situation where maybe it does make sense to gift it to them while you're alive as opposed to at death. Again, you just want to talk these things out with someone who has an understanding of them, just just that little bit of knowledge might have saved 10 grand, 20 grand. Again, you just want to talk all these things out. Elder care planning. This is a tough one. And, it's like I always tell people, tell me when you're going to pass away and I'll tell you exactly what to do. Tell me if you're going to have an elder care problem and I'll tell you what to do. Because it's, in one situation, maybe you're half the country that just passes away in your sleep. And you didn't have to worry about any, assisted living facility and $15,000 a month of costs because it was quick, it was sudden, boom, it was over. Now, the other half the country tends to be a little bit more of a female problem. Claims for long-term care are like 5 times more for women than it is for men. Women live longer, and it's just a reality. Men just call it a day. That's just at least what the statistics shows. But there are ways of protecting your estate from assisted living facilities, long-term care situations. What I tend to recommend people do is somewhere in the 72 to 77 range. Because you have to think a lot of these planning to 5-year look back. Medicaid will look 5 years back on did you gift any money away to other individuals to trust? And if you did, they're going to claw it back before you're eligible for Medicaid. Now, you'd be like, I'd love to say we can protect everything. You can't really do that. For one, you can't put IRAs, 401ks, Roths into trust. So they're going to stay in your estate. Now, almost like the IRAs and the 401ks are good sacrificial lambs. And the reason I say that is, if you do find yourself in a assisted living facility situation, those are high medical expenses, big tax deductions. Big tax deduction means we can take money out of IRAs and 401ks and it comes out tax-free because we have a deduction that's sitting there waiting for us. So if we have the thought process of, if I have to go in an assisted living facility, does the assisted living facility want? They want to be able to self-pay for at least 2 to 3 years. So, it might be a situation where you're moving your home into a trust, some of your liquid non-retirement money into a trust, but we can't protect everything. Now, those types of trusts aren't fun. They're irrevocable. That means they have to do their own tax return, which comes at their own cost. You have to have a third-party trustee. The tax obligation has to flow through typically on the lifetime beneficiaries, which is going to impact their tax return. So there's no wonderful reality that solves everything. Everything has its own pros and cons to it. So, like I said, typically in your mid 70s, you sit down with an elder care attorney, you weigh the pros and cons, you analyze your situation. Can I do something? Sometimes, you might not care. Hey, this money is for me and my benefit. If I live 8 years in a assisted living facility, I don't want them trying to pull a fast one and I get dumped into a crappy facility. You just got to prioritize and rank your needs and wants. But again, around mid 70s is when you have these conversations to see if there's anything you need to do. And that assumes you didn't put long-term care insurance in place. Long-term care typically, again, it's one of those where somewhere between 55 and 60, I like people to have a conversation. Does this make sense for me? Does it not? A lot of times I do not think it makes sense, but you have that sit down conversation and you think about all the angles. Now, just so you know, elder care planning is not cheap. You might spend, you know, ten to $15,000 of putting these things in place, but it might be a situation where you spend 10 grand to protect $250,000. So again, you're weighing um, the pros and cons there. Now this is a big one. A lot of people, at 60, I put my wills in place. I really did a good job. I did everything on my wishes, you know, and then at 72, I moved to Florida. You kind of have to start all over again. Um, Other states have different rules, different priorities, different pain points. So all the time people move down to Florida. I say, highly recommend sit down with an estate planning attorney in Florida, take a look at your documents. Maybe you don't have to replace all of them, but have the conversation. And also have the understanding of, where someone passes away, where their primary residence was. Did they have a business in another state? All these things have their own special little rules. So if you have a piece of real estate in another state, know their estate planning rules. So again, just have the conversations. Charitable wishes. Again, this goes back to planning. While you're alive, that has nothing to do with your core four documents. So let's give an example. I want to leave 50% of my estate to charity. Well, let's say you have 500 grand in a 401k and 500 grand in a bank. Well, that you want to, have to go to your kid and have to go to a charity. Well, a lot of people just blindly put 50% of the IRA goes to the kid, 50% to charity, 50% of the bank account goes to each. Well, IRAs are horrible to inherit. You got to pay income tax on it, and it has to be distributed over the next 10 years. When a charity gets an IRA, they pay nothing. So you're in this situation, much better for your kid to get 100% of the bank account and the charity to get 100% of the IRA. So if you are charitably inclined, typically your will, laying it out there, is not the best spot. It's to put it as a beneficiary on a retirement account. Now, we really didn't go through anything tonight with regards to large estates. And by large estates, I would say anything more than 15 million. If you were a couple above 30 and you have money in your estate, 40 cents on the dollar is going to Uncle Sam. So if you do find yourself in that situation, 100% more detailed planning. So I had the privilege of sitting down with someone who has about a $60 million estate, and I was just blown away at the different trusts you can put in place to kind of mitigate and lower your estate while still having control. Let's just say there's a decent amount of loopholes built into the system. But again, tonight, I just wanted to get some fundamentals of estate planning in place, some things to think about, some ages to have some benchmarks to know when you have to have certain conversations. If you're sitting here and your kids are out of school and you still have the, will from when they were born, probably a good time to look it over. I think if I were to break it down, if you were going to do three, Yeah, when your kids are young, put that estate plan in place. When you're, let's say, around 60 and you have much more of a net worth, you might have want to have a little bit more control. You see what type of kids you might have. You might have another new estate plan in place where maybe you're having a trust or two. And then, like I said, your mid 70s, that's when we have to think about elder care planning, if there's anything special we want to do in that particular situation. Those are the three definites, but yeah, every few years, take a look. Is there anything you want to tweak and adjust? Maybe a little bit more to this person, a little less to this person. You'll find your own personal sweet spot. I hope I gave some people some things to think about. I'll pause here to see if anyone has any questions. Okay. Well, again, I hope everyone enjoyed themselves. If you need anything, I'm always here. A lot of times, just hey, let's jump on a Zoom meeting for half an hour and just kick it around and see if something speaks to us or see if there's some angle we haven't thought about. But thank you so much for coming tonight. It's a pleasure as always, and I'm sure I'll talk to you all soon.